Hello, my name's Dr. Tom Smith. I'm a senior lecturer in law at the University of the West of England in Bristol, and this is a video abstract for my article Rushing Remand, Pre-Trial Detention and Bail Decision Making in England and Wales. Pre-trial detention and bail are an important power of the police and courts, my focus in this article being on its use by the courts. It's particularly important as a tool for managing persons accused of criminal offences at the very earliest stages of an investigation and then prior to trial. But obviously any deprivation of liberty of this kind has significant implications for the presumption of innocence. It's a very significant intrusion into the individual rights of somebody accused but not yet convicted of an offence. So this article essentially provides a focused examination, an empirical one, of the remand decision-making process in England and Wales. Now this is a common part of criminal procedure but is underexplored, certainly in recent years. So what the article primarily does is presents some key findings from the first large-scale study of pre-trial detention and bail decision making in around 2 decades. And what it primarily focuses on are 3 key issues. Firstly, problems with disclosure of evidence prior to pre-trial detention decision making. So for example, failures to provide extensive evidence or core information that suspects and their lawyers, as well as the court, should have in order to make appropriate remand decisions. So issues with disclosure is one issue that the article focuses on. The second is the issue of time, and the key finding of the article that remand decision making hearings tend to be swift, lacking in extensive detail, and often have problems with depth in terms of relating decisions to the facts and circumstances of the case. And that leads me on to the third key issue discovered as part of this empirical study, which is that reasoning for decision making by magistrates and district judges tended to be formalistic, very brief, and lacking specific detail about why a particular decision to either remand somebody in custody or release them on bail was made. So those are the major focuses of this article. And what it does is firstly explores in some depth the academic context for this, previous findings of historic research, which to a great extent are reflected in this new study. And then goes on to look through the data found in this study to expand on those issues, and finally close with some recommendations for change to ameliorate these problems, particularly that there should be more of a focus on devoting a little more time to detail and depth in the decision-making process, ensuring that disclosure, important disclosure of relevant information happens prior to hearings, and that reasoning for decisions is very clear and linked clearly to what is happened in the case, rather than being generic or vague. The aim ultimately is for this study and for the article to raise awareness about this fairly neglected area of research into criminal procedure, one that really deserves more attention, because the deprivation of somebody's liberty before they've been convicted of anything is clearly significant and has great implications for all sorts of things, employment, for family ties, but of course also for the suggestion that that person may in fact have done what they've been accused of, despite there having been no trial at that early stage. It's hoped that some reform will flow from the findings of this article, and that more attention will be paid to dealing with these issues, which appear to be commonplace in the future. So I hope you'll enjoy it and find the findings interesting and useful. Thank you.